Hello, 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 hello. Welcome to my channel. My name is Shirley. Welcome to my YouTube channel, Shirley's Channel Chatter. So, my channel here on YouTube, I have 3 channels, so plural. Shirley's Channel Chatter, Just Me and Shirley, Everything Shirley, actually 4, and Education Unlocked. So I just started these channels and I want to build on all of them. But my concentration is mostly on Shirley's Channel Chatter right now. So this channel will be geared toward business, law, accounting, ancient philosophers, legal issues in the news, current legal issues in the news, law terms. So business, marketing, advertising, promoting, target markets, marketing channels, competitive advantage, comparative advantage, customer service, customer satisfaction, anything business I want to deal with. I want to talk about, I want to deal with, I want to do some research, I want to learn some new topics, new terms when it comes to business, international business. Just everything relating to marketing. In other words, marketing the product, marketing the service, everything that can help benefit a business, everything that can help a business grow. So basically, I had several businesses, but right now I'm taking a step back and just, I just want to do some research on different topics related to business, accounting, law, ancient philosophers. I want to also do some research on some, discoveries, people that did different, discovered different things, different places like Balboa, Christopher Columbus. I want to go way back, so I just have big plans for my channel. But let me start with saying, first of all, I used to market wigs and make wigs, so that was one of my businesses. So, actually YouTube was my best friend. So I went to YouTube and I found out how to make them. I got my mannequins, my wig caps. And so these are the mannequins. So I'm not going to talk about this today, just showing you this real quick. But today I want to go over some law terms. My mannequins. So my mannequins, my wig caps. And then, you get the thread and needles. Thread and your needles and your hair. So your hair. So whatever kind of hair you want. So I have to have my hair. So I'll start out on the back. And I draw my lines over here all the way across. But I would need a frontal. A closure or frontal to put on the front, and then I start with my lines on the back, and then I open my hair up, and then I'll stitch it all the way across from here to here, and then as you go up, you go all the way up, then your frontal or your closure at the top, and then you finish it off. So just wanted to mention that today. And I'm not going to deal with this right now. So that was one of the businesses that I did have. And also my book collection, my children's books that I write. And also now, I'm focusing on my doll collection. So I have my doll collections. I'll have my my doll collection. So my doll collection. So I may be marketing these. This will be my second business, and I also have some Barbie dolls. So I have these are the life. I think they call these lifelike dolls. Yeah, lifelike dolls. So I have a collection of these. So these might be my second business. And like I said, making my wigs will be another little business. And then I have my children's book line. But let me get on to what I want to talk about today. So I definitely would have more dolls. So this is, this is a hobby right now, a collection. So I'm not stepping into any business right now, but I'll just be working on making my wigs, purchasing different types of hair, making my wigs. So when I do my videos, I'll talk about those, but I'm not marketing anything right now. And then I'm still collecting my Barbie dolls and my lifelike dolls. And I also want to collect some Elsa dolls. I like the Elsa dolls. And I also like, I think, what you call those dolls? Great American dolls. I think they're called Great American dolls. I want to work on, collecting those as well. And see on the back, you can, So all my little Barbie dolls. I think I got about 15 or 20 dolls all together. But, so today I want to talk about I just want to shed light on some law terms. So today I want to shed light on some law terms. So, like I said, my channel will be geared toward, legal issues in the news. Different cases, current cases in the news. But today I just want to talk about some law terms. The first term is hearsay. So hearsay, that's evidence presented by a witness who did not see or hear the incident in question, but heard about it from someone else. With some exceptions, hearsay is not admissible as exceptions at trial. So let me look it up and see what else they have to say about hearsay. So just a few legal terms today, and then I also have a list of Greek philosophers. A list of Greek philosophers that if I have time, I'll go over them today. So that's the first word that was hearsay. So let me see what else I can find out about hearsay. So hearsay, I have inculpatory evidence, indictment, injunctions, and interrogatories, oral arguments, and I have per curiam and peremptory challenge, petty offense. So let's start out with hearsay. Let's start out with, let's start out with hearsay and see what else they say. But that's just evidence presented by a witness who did not see. So in other words, hearsay, if somebody, something happened, like an accident or whatever the case may be, but the third party was not involved, or did not, they wasn't involved, but they didn't see what happened, and they wasn't involved either. They wasn't there. They didn't see what happened, but they had an opinion about what happened. So in other words, evidence presented by a witness. Well, I guess they did have to witness it, but that's still hearsay. If they say evidence presented by a witness who did not see, so in other words, they didn't see or hear it. So how are you going to be a witness if you didn't see or hear it? But that's what the definitions say. So if it say hearsay, so hearsay meaning, so in other words, but you didn't see or hear, but that's still considered hearsay. See, hearsay, information received from other people that one cannot adequately substantiate. Rumor, according to hearsay, Bob had managed to break his arm. In other words, Bob broke his arm, but you didn't see him break his arm, so hearsay. Or you could say Sally hit Jane. Sally hit Jane. You saw Jane had a bruise on her arm or a black eye. Sally hit her, but you didn't see Sally hit her. You just assumed, so that's hearsay. That's like a third party. In other words, a third party person is a third party. They didn't see or hear. So it's evidence presented by a witness who did not see or hear the incident in question, but heard about it from somebody else. So they heard about it from somebody else, so that's hearsay. Like somebody say, oh, Johnny, somebody told you Johnny fell off the porch and, broke his leg. You heard about that from somebody else, but you didn't see it, but you heard it from somebody else. So that's hearsay. So I just want to get a clear understanding of hearsay. So hearsay definition and meaning. So it says like a rumor, like the hearsays bandied about by the medievalists. Hearsay evidence. In other words, you heard about it from somebody else, so that's hearsay. So just want to get that. All right, we go to the next one. The next one is inculpatory evidence. So it says evidence indicating that a defendant did commit the crime. So inculpatory is like you are getting the blame for that crime that happened. So let's go. Let me try INCULPA, inculpatory. So it says evidence indicating that a defendant did commit the crime. So yeah, so implying or inputting guilt, tending to incriminate or inculpate an inculpatory statement. So in other words, implying that the person did commit that crime. So you blamable. It's like blamability. So inculpatory. Then we have indictment. INDIC. So let's look up indictment. So these law terms. So indictment is a formal claim of criminal wrongdoing against a person that the prosecutor gets an indictment for 90% of his cases. So there's, in other words, somebody commit a crime and they let me see if I get a better definition than that. I'd like to get the clearer definition. Let me get a clear definition. I like the definition so I understand it better. In other words, you hear the term, but you heard the term before, but you want to be able to, you don't want to have, I don't like explaining nothing, or I don't like seeing definitions for words and then it's not understandable, then the words, it doesn't explain it. INDICT. So indictment meaning. So we know an indictment will probably come from the prosecution. So indictment as a formal charge or accusation of a serious crime. That's what it has. Let me see what else they have. It says, what does it mean when you're going to be indicted? Usually indicted to the grand jury. When a person is indicted, they are given formal notice that it is believed that they committed a crime. The indictment contains the basic information that informs the person of the charges against them. In other words, a person is indicted, then that they're going to be formally charged with that crime. So that's what the indictment is. It says, so it says an indictment is a formal accusation that a person. So in other words, formal means they probably want, everything will be down on paper, you'll be formally charged for that particular crime. So it's a formal accusation that a person has committed a crime. In other words, it's not nothing. It's not merely enough to just say it, word of mouth. So formally, in other words, the court, definitely will come from the court. So let me see. It says a formal written statement framed by a prosecuting authority. I think it comes from the prosecution. A formal written statement framed by a prosecuting authority and found by a jury, such as a grand jury, charging a person with an offense. So that is an indictment. That was inculpatory. Now let's look up injunction. Injunction. So injunction is, I have a whole list, like three pages. So an injunction, let me see what that is. Okay, injunction, an authoritative warning or order. A judicial order that restrains a person from beginning or continuing an action, threatening or invading the legal right of another, or that compels a person to carry out a certain act to make restitution to an injured party. A judicial order that restrains a person from beginning or continuing an action, threatening or invading the legal right of another. So somebody get an injunction against somebody. It's a judicial order, so that comes from the court, and it restrains a person it restrains a person from threatening or invading the legal right of another. So somebody get an injunction against somebody, then I guess they have the right. I'm thinking if is it monetary? So it doesn't say that here in the definition, a judicial order. Let me go further down, because I'm trying to figure out, is it, in other words, you get an injunction against somebody. I'm trying to see, okay, here it is right here. Let me go here. What is an injunction? See, in law, an injunction is an order by a court to one or more of the parties in a civil trial. Okay, this is a civil trial, to refrain from doing, or less commonly to do, some specified act or acts. The former kind of injunction is called prohibitory or preventive. The latter mandatory. The usual purpose of an injunction is that's what I want to get to. The usual purpose of an injunction is to preserve the status quo in situations in which further acts of a specified type, or the failure to perform such acts will cause one of the parties irreparable harm that cannot be adequately remedied by an award of monetary damage. That's what I want to say, monetary damages. Preliminary or temporary injunctions are usually issued before the start of a trial. They expire upon the resolution of the proceeding or at an earlier specified time. Permanent or perpetual injunctions may be issued at the end of a trial as part of the court's final judgment. They usually enjoin the specified act or acts permanently or for as long as the relevant circumstances obtain. A temporary restraining order is an unusual type of preliminary injunction that is issued without a hearing or sometimes without notice to the party against whom it is directed. It is valid for only a short period or until such time as a formal hearing on a preliminary injunction may be inducted. In order to be granted an injunction, the plaintiff must demonstrate. So it comes in under civil law, so this must be under civil law, tort law. Civil, not criminal, civil law. In order to be granted an injunction, the plaintiff must demonstrate that he is likely to suffer irreparable harm without it. That the injunctions benefit to him outweighs its burden on the defendant, that the injunction is in the public interest, and that he is likely to succeed in the eventual trial. Failure to comply with an injunction can result in a charge of contempt of court. So somebody get an injunction against somebody else, and in other words, they have to refrain from doing something, or in other words, when it comes to civil law, they would refrain from doing something. In other words, they would have to pay those, I guess those money damages. So somebody get an injunction against somebody when it comes to civil law. It said preliminary and permanent injunction may be sought to prevent the bulldozing of a historic building, the pollution of a public water supply, the infringement of a copyright, the manual recounting of ballots in a presidential election, or the enforcement of a constitutionally suspect law or executive order. In the area of family law, injunctions may be used to end harassment by an abusive domestic partner, or to, I see, I think I get a little understanding of it now. So in other words, somebody gets an injunction against somebody else, that makes them stop, that puts a stop to them harming the other party. In other words, like they said, somebody can get an injunction against a person, an abusive domestic partner, in other words, to stop them from, doing the abuse. So you had, court order to get that person to, stop doing what they do, what they're doing. So they need the injunction. So it can come in family law, it can come, injunctions may be used to end harassment by an abusive domestic partner, or forced payment of child support. So it was right, forced payment of child support, or stop the abusive domestic partner from further abusing their partner. So get an injunction. Then they also said preliminary and permanent injunctions may be sought to prevent the bulldozing of a historic building, pollution of public water supply. Right, okay, yes, I'm getting a better understanding. In other words, what if there's a company and it's they marketing water. They're marketing water, but it's hazardous to people's health. And if people find out about it, they know, a lot of people know, hey, this water is hazardous to our health. And, people buying the water, and the water is still on the market. But then there's some, they can get an injunction to make those companies, stop selling that water. Because the water is hazardous to people's health. The water, that water supply is hazardous to people's health. So, get a court order, get an injunction, that way the company can stop selling that water. And then bulldozing of a historic building. So in other words, I guess they have a company maybe want to tear down some buildings or something like that. They want to tear down them buildings, they want to use a bulldozer, making all that noise, and then they want to do that around other people's homes and stuff. So the people get together and say, hey, we don't want that, noise around in our neighborhood where we live, where our families, our kids, we don't want that in our neighborhood. So we want to get an injunction so they can put a stop to that. Put a stop to them using them bulldozers and tearing down these buildings and, historic buildings. They say historic buildings in here, but it might not have to be a historic building. It could be another kind of building. It could be another kind of building. And then I know I took a course called Business Ethics, where it was a company, and it was an article in a book where this company was dumping hazardous chemicals near people's homes, in landfills near people's homes. So then that would be a good example as well for those people in that neighborhood to go to the court, petition the court. Get your lawyer if you have to, but petition the court and get an injunction to stop those companies from, dumping all those hazardous chemicals around people's homes. So that would be, now I was just wanted to make sure I have a clear understanding of injunction. And so let's go to interrogatories. So we know lawyers deal with the interrogatories. So let's go with interrogatories. NTEE. Interrogatory. So I got a better understanding of injunctions. Let's go with an interrogatory. A written question which is formally put to one party in a case by another party and which must be answered. So interrogatories is which is formally put, is a written question is formally put to one party in a case by another party and which must be answered. So in other words, I assume the lawyer will be the one to administer these questions to the other party. Not, you have two sides in the case, so one party will have their lawyer, I guess they have their own lawyer, they have their lawyer submit those questions. So it says a written question, sure, it's probably more than one question, but the definition says a written question which is formally put to one party. I assume it's more than one question. Let's see, who can be served interrogatories? Who can be served interrogatories? Interrogatories may without leave of court be served on the plaintiff after commencement of the action, on the defendant with or after the service of the summons and complaint on that defendant. Each separately represented party may serve no more than 20 interrogatories upon each party. A discrete subpart of an interrogatory counts as a separate interrogatory. So it says on a defendant with or after the service of the summons and complaint on that defendant. So in other words, this seems like this is this could be under criminal law too, as well as civil. So in other words, somebody gets a summons, summons and a complaint on the defendant gets a summons and a complaint, and also he may be required to answer some questions. Those questions, called the interrogatories. So it says who can be served interrogatories. It says, do interrogatories need to be filed with the court? So let me see. So it's different questions, okay? Interrogatories are written questions to be answered. Interrogatories are exchanged between parties to the case. So in other words, they're exchanged. You have two parties in the case. They can be exchanged within those two parties, which would indicate you as the plaintiff and the defendant or defendants. So you have the plaintiff and you had the defendant. Somebody had the defendant had the plaintiff sent the defendant a summons, and they sent the summons and a complaint, and then also they wanted the defendant to answer some questions called the interrogatories. So it says what happens once you receive an interrogatory. All of the questions must be responded to in writing, and it must be done under oath. So in other words, you're a defendant in a lawsuit. You're a defendant in a lawsuit, and you have to answer these interrogatories under oath. So you have the plaintiff submitted, they submitted the summons to you. You receive the summons from the court, rather, and then you receive the summons from the court because the plaintiff wanted to initiate a lawsuit, against you. So you have to. Then they also want you to, answer these questions under oath, which these are the interrogatories. So let's see. The next one is, let's go to oral argument. Oral arguments from 1 one lawyer. So I assume both lawyers on each side will present their oral arguments and their closing arguments at the end. So let's look at the oral arguments. Let's look at the oral arguments. Okay, oral arguments are spoken representations to a judge or appellate court by a lawyer. So, of the legal reasons, so a party when representing themselves, of the legal reasons why they should prevail. Oral argument. Oral argument at the appellate level accompanies written briefs, which also advance the argument of each party in the legal dispute. So I assume oral arguments don't just have to be at the appellate level, appellate courts, court of appeals. So, but it just say right here, an oral argument at the appellate level accompanies written briefs, which also advance the argument of each party in the legal dispute. So let me go down here to oral arguments. Oral arguments. See, you said oral arguments at the Supreme Court, but I was trying to get the. Okay, let me go here and say who should do the oral argument. I assume both lawyers, the lawyer for the defense and a lawyer for the the prosecution. I assume both sides would do the oral. I thought it said the oral argument on appeal is the culmination of the attorney's advocacy effort on behalf of his client. Oral argument to any appellate level court is nothing more than an attempt by the advocate to persuade the court. So the oral argument is just they want to persuade the court. In other words, they're trying to persuade the jury, basically, to say, hey, in other words, I'm a lawyer. My oral argument, I want to try to persuade the jury. So do they have a jury? Let me see. It says oral arguments to any appellate level. So that's the court of, but this is some of the court of appeals, appellate level. It's nothing more than an attempt by the advocate to persuade the court to understand the case from the advocate's point of view, give the court information necessary to the decision-making process. Yeah, so oral arguments is you want to persuade the court. You want to persuade the court your way on your side. So your verbal skills, the words, you want to be the one that they believe. You want to be the one that's you want to be the one that pick out the right words to say when you're giving your oral argument. Your oral argument. It says, what is an oral argument in civil law? So let me see. So that's what I'm saying. Because the oral arguments, I figure it could be. You can use that in a civil case or a criminal case. It says oral argument in civil law simply means that the parties present their legal arguments. That's what I'm saying. Both lawyers present their legal arguments to the court. It is not a debate exactly what each side takes turn. It's not a debate what each side takes turns presenting their side of the case and asking for a judgment in their favor. In other words, I want to get up there. I'm the lawyer. I want to get up there and make them believe me. Make them believe what I'm saying as opposed to the prosecution's attorneys. I want them to believe me. I'm working for the defendant. I am the defense attorney. It's not a debate exactly what each side takes turns presenting their side of the case. And this time, I don't understand. Sometimes they said it is not a debate exactly. So in other words, it's not a debate exactly what each side takes turns presenting is their side of the case and asking for a judgment in their favor. A rule to show cause occurs when the court wishes to compel a party to litigation to explain certain actions. So basically, your oral argument as an attorney, you want to get up there, you want to persuade. It's not a debate, but you just want to persuade them, the jury, or you want to persuade the jury, or you want to persuade the court to believe what you're saying about your client. No, my client, no, he blah, 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 he blah, 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 and this and that, So, matter of fact, let me see. Let me see if they have any examples of any oral arguments before I go on. Oral arguments examples. I just want to see what they're saying. Because sometimes, you look at TV shows and you might see, moot, I guess they would call it. It's not necessarily the moot court, but it's just, different cases. It might be a case over there. You might be watching a movie like a movie on Lifetime, Movie Network or Lifetime, or whatever, Netflix or whatever. And then, they have a court, they have a court trial. Let me see. It says sample oral arguments, Eric Brooks versus Bayless v. Okay, look, greed and gouty examples. Let's see. Let me see one right here. Let me see. How to write an oral argument. Write out your oral argument in its entirety and think that you should read from it or even consider that you will be able to memorize it. The oral argument is constant interchange of ideas between the bench and the advocate. Therefore, you want to maintain as much eye contact as possible and remain flexible enough to engage in dialogue. How to do an oral argument. So just, I just want to see what they're saying. After filing an appellate brief or a motion, you may have the opportunity to present oral argument or to present oral argument to, I don't like the way they present their English. After filing an appellate brief or a motion, you may have the opportunity to present, I would say an oral argument, but they didn't have an on here. They said you may have the opportunity to present oral argument. No, it should be you may have the opportunity to present an oral argument to the court. Whether you are speaking in front of the Supreme Court or in law school, moot court, as I was saying, oral advocacy is an important part of convincing judges to decide in your favor. So you want to convince the judge to decide in your favor, you will need to extensively prepare, understanding your case inside and out, and present arguments in a clear and convincing manner. I should be a lawyer. I should be in law school. I took business law at Australia University. I did pretty good. My teacher came back to school the next day. We had an assignment to do, and we all, I presented my assignment to the class. I had to stand up, and a couple of my other classmates presented their assignment. So the next day, when the teacher came back, he said, I have 3 students that should go to law school. And he called my name. He called my name and a couple other students, and everybody, the class started clapping. So I did finish my paralegal. I do have my paralegal diploma, but law school is something I, still always wanted to do, but right now I'm just doing my little research. So understand the purpose of an oral argument. After submitting a brief or motion to the court, you have the option to present an oral argument. The purpose of an oral argument is to help clarify the issues for judges and address any concerns that they have. You should think about oral arguments as a dialogue that you will be having with the judges. The judges are not the enemy. Judges may ask hard questions because those are the issues they are grappling with. Not every hard question is an attempt to trip you up. A lot of people be scared of the judges. Lawyers may be scared of them, but some of them may not. That's what they say right here. Look, judges are not the enemy. But if you're the defendant, you think about the judge as the enemy. You might be thinking about the judge, oh, that's my enemy, because he gonna make it hard for me. But sometimes you never know. Not every hard question is an attempt to trip you up. An oral argument is most associated with appeals. After the trial court renders a decision, the losing party can appeal, right, in the appellate court. This person is called the appellant. The other party is the appealee. Appeals are usually heard in front of a panel of at least 3 judges. See, hear that? Appeals are usually heard in front of a panel of at least 3 judges. Trial courts will also hold oral arguments for critical motions, such as a motion for summary judgment or a motion for a new trial. Motion for a new trial. So there are some cases in the news now that I think they'll be getting a new trial. Some current events, so I probably will be, once they come about, I definitely would talk about those when the time comes. So let's see. Now we have, let's look up per curiam. It says for the court. Let me see what else they have for that. Per curiam, for the court. So it's just some, legal terms. Just want to go through a few legal terms. P-E-R-C-U-R-I-A-M. Let's see what this means. It says for the court. Per curiam. Okay, what is per curiam? Yeah, per curiam. The per curiam meaning refers to a written decision made on behalf of the entire court. Rather than signed by one or several named judges. For example, per curiam decisions do not typically occur at the Supreme Court because one of the judges would typically sign off on every decision. So let me get some more information on the per curiam. I've never even heard of this term. So it's a legal dictionary. The term per curiam refers to a decision made by a court of numerous judges. So numerous judges, but right here they just said for the court. Decision made by a court of multiple judges as a whole entity rather than signed by one judge. So that's what that is. And it says, for example, per curiam decisions are typically short and concern issues that the court does not consider to be controversial in nature. However, this is not always the case, as sometimes the judges do not make per curiam decisions unanimously, the topic still being controversial. To explore this concept, consider the following per curiam definition. A decision made by a court of multiple judges as a whole entity rather than signed by one judge in particular. So, okay, they had the same definition twice. When a decision is per curiam affirmed, this means that a court affirms the decision of a lower court to be correct without naming names. When a court makes a per curiam affirmed decision, it typically does not offer an opinion past the affirmation. This is perhaps a way for the court to cut back on what are already scarce judicial resources. Put another way, if they had to write a full opinion on every case they decided, they would end up wasting more time than simply making a per curiam affirmed decision, which does not need further explanation. So it typically does not offer an opinion past the affirmation. So in other words, when a decision is per curiam affirmed, this means that a court affirms a decision of a lower court to be correct without naming names. So in other words, I guess the per curiam is a faster way for them to reach a decision on these certain cases. Because they said if they had to, do a whole lot for this case and that case, and they had to write a full opinion for every case that they decide. If they had to write a full opinion for every case, it would take a long time. I mean, it takes enough time anyway when you have a case. In some cases, it can last you up to 6 months to a year, depending on, the case. So that is per curiam affirmed. So that, that's a pretty good term. Let me see. Okay, hold on. Let me see. Oh, I got another one right here on this page. 2 more on this page. Peremptory challenge. Let's see what the definition of that is. It says a district court may grant each side in a civil or criminal trial to exclude jurors without cause. So that's what that means. Let me see what else I like to see what else they have, because I was just writing those definitions down fast. And this is a peremptory challenge. Peremptory challenge. So, just a few little definitions. Let's see. Few definitions. So, peremptory. Peremptory challenge. There you go. Peremptory challenge. And in American and Australian law, the right of peremptory challenge is a right in jury selection for the attorney to reject a certain number of potential jurors without stating reason. Other potential jurors may be challenged for cause by giving a good reason why they might be unable to reach a fair verdict. So in other words, the peremptory challenge, in other words, they're saying that it gives the lawyers, I guess, a right to, be able to excuse some jurors that they don't feel that they want to, represent the case, be on the case, be involved in that particular case. So it says, the right of peremptory challenge is the right in jury selection. So when they're selecting, so I think what they call it, voir dire, something. I can't even say it right. Voir dire, that's the jury selection. The right of peremptory challenge is the right in jury selection for attorneys to reject. So in other words, the attorneys can reject a certain number of potential jurors without stating the reason. They can just look at the jury when they're doing a jury selection, and then say, hey, what's in their mind. They looking right, because I've been on jury duty. I served jury duty 2 or 3 times. So in other words, it says the use of peremptory challenges is controversial, and some feel it has been used to undermine the balanced representation on a jury, which will occur using random selection. So in other words, that's almost a way they could also undermine the defendant, when they picking who they want to pick. I mean, they have the choice to do that anyway, but it's almost still, when you're in that position and you are the defendant, you be like, you'll be feeling a different type of way. Because you like, look, you feel that they picking people that will be to your disadvantage. Of course, the prosecution want to pick somebody that's not going to be to your advantage, so that's how that will go. It says in Argentina, the majority of the provinces in Argentina allow 4 peremptories per side and limitless challenges. So that's in Argentina, and it says you can see more. Let me see what else they said. It says the rules regarding peremptory challenges in Canada were laid out in the Criminal Code of Canada. The number of challenges awarded to each of the prosecutor and the defense depended on the type of charge and maximum potential sentence. 20 challenges were awarded in cases for high treason and first-degree murder. 12 challenges for offenses with a maximum penalty greater than 5 years, and 4 challenges for jury-eligible offenses with a penalty of 5 years or less. In cases where the judge orders 13 or 14 jurors instead of the usual 12, both sides receive another challenge per each additional juror. So then they have different countries. Now in England, they dealing with, they have a whole lot. See, England, they deal with the peremptory challenges where they were first used in England not many years after the assizes of Clarendon of 1166 allowed jury trials. When the concept was first introduced into the jury system, the maximum number of peremptory challenges allowed was 35. And then they got Hong Kong, They deal with the peremptory challenges too. They were permitted in Hong Kong. Unlike England, no statutory change has been made to abolish the right. So these different countries, they're using the peremptory challenge as well, where they can pick where they have a right to, they can just, they see some jurors when they're doing a jury selection, they can say to themselves, I don't like this juror, they say it in their head. And then they can just excuse the juror. They can excuse the juror, they can pick and choose, and they can excuse the juror and they don't have to make no explanation about why they excuse the juror. So that's something. Then they have, because they have England, they deal with the peremptory challenges. Hong Kong, peremptory challenges, they're permitted in Hong Kong. Then Ireland, peremptory challenges are permitted in Ireland, with each side being allowed 7 such challenges. And then we have New Zealand. Each party is entitled to 4 peremptory challenges in New Zealand, and where there are 2 or more accused, the prosecution is provided with a maximum of 8. Then we have Northern Ireland. Unlike the rest of the United Kingdom, peremptory challenge survived in Northern Ireland into the 21st century. The juries ordered in 1996, they entitled each party to a maximum of 6 peremptory challenges. In civil cases and criminal cases, each defendant was entitled to a maximum of 12 peremptory challenges, and each prosecutor could only challenge for cause. So that's something. Then in the United States, right over here where I'm at, I'm in the United States. I am a United States content creator. Nearly all jurisdictions in the United States allow for peremptory challenges. The number depends on the jurisdiction and the type of case. More challenges may be permitted in a case than for a DWI. On August 24, 2021, the Arizona Supreme Court enacted a rule change eliminating peremptory challenges in both civil and criminal cases, making Arizona the first state to end the practice. So Arizona, they don't have the peremptory challenges where the lawyers can just excuse these jurors. No question, they don't have to answer no questions. So they can say, I'll excuse this one, I'll excuse this one, this. And they have, each state, they have a different amount, a different number that they can excuse. Okay, that is, I guess it says another form of the peremptory challenge available to some jurisdiction is the right to remove a judge assigned to hear the case without showing that the judge is actually biased or had a conflict of interest. So, but this don't say what state or country this is in. It just say another form of peremptory challenge. That means peremptory or disqualification. That's what that means. In other words, they disqualify peremptory challenges in different countries, different states. They're disqualifying the jurors. Because I wish they would have disqualified me when I went. And they say, we'll disqualify her, bam, you can go. Well, actually, determination of a judge's bias is not required to employ the peremptory challenge. The moving party must still allege bias under oath. So this is another word they say they can remove the judge. So they can also do the jurors and the judge. It says another form of the peremptory challenge available in some jurisdictions is the right to remove a judge assigned to hear the case without showing that the judge is actually biased. So they don't have to show the judge. In some jurisdictions, they're saying, but they don't say which ones. But they don't even have to show that the judge is actually biased or had a conflict of interest. So that is it. Let me go to the next word. Let's go to a petty offense. So that's a good term to know about peremptory challenge. I never heard of this word. But that is, let me go to petty offense. So I have, I still have my notes right on my paper, all my terms. So summary of the petty offense in the United States federal and state law, there are certain minor or petty offenses that may be proceeded against summarily and without a jury. So it says extradition law in the United States, charged with a felony, misdemeanor, or even petty offense in another U.S. state or territory, even if the offense is not a crime in a custodial state. But let me see, I guess the petty offense will be an offense of a certain amount. I would assume it's a petty offense, and this is Germany. Every German municipality and city, minor or petty offenses are called Ordnungswidrigkeiten, meaning offense. That's a long word, or rather, contrary to public order. Let me see there. Now, let me go up here. Let me go back up. Let me go back to the top. Let me go to Google, because I usually like Google. Let me see, petty offense. It's offense. So I assume that is an offense, it's a minor. Petty offense is a minor crime that maximum punishment for which is generally a fine or short term in prison or house of correction. House of correction. In some states, a petty offense is a classification in addition to a misdemeanor or a misdemeanor and a felony. So it doesn't say that it has a certain amount, but it just say a minor crime, the maximum punishment for which is generally a fine or short term. So in other words, a petty offense, the maximum punishment is generally a fine or short stay in prison or a house of correction. So that would be a petty offense. So in other words, you're not looking at no major time. In other words, it's a petty offense. What are some examples of petty offenses? What are some examples of petty offenses? Possessing a crack pipe, possessing a bottle cap containing a trace amount of something, having traces of cocaine, might well say the whole word, having a single crack rock at home. So in other words, you got a single this and you got a single that. Let me see, it says petty, what is a petty crime? It says petty crime. What are some examples of petty offenses? Okay, here was some big these are the petty crimes. Traffic and moving violations, those are petty offenses. Traffic and moving violations including those petty crimes that involve vehicles or the rules of the road. Yes, I've been in several car accidents, and your insurance usually take care of it, but you have to over here in the United States, if you hit somebody, you get in an accident, you hit somebody's car, they hit your car, you just have to stay there at the scene, exchange information. We exchange our insurance information. We have to have car insurance. We exchange our car. The company that we get our car insurance with, a van or whatever we have, but our vehicle insurance, I would just say. Vehicle insurance information, your name, maybe your phone number. And you can also call the police and have them come to the scene. It depends, how bad the accident is, because if your car is hit real bad, total loss, or people got hurt, they may need an ambulance, but you just have to make sure you exchange information. So you hit somebody, exchange each other's information, insurance information, car insurance, vehicle information, name, phone number. So that's what they said, petty crime list, traffic and moving violations. Traffic and moving violations include those petty crimes that involve vehicles or the rules of the road. Harassment not involving actual intent, assault of the body, theft or removal of property. So in other words, you go on somebody got an Amazon package, you run up on their porch and steal their package. You say theft or removal of property. property. So you go steal somebody's Amazon package off their porch, or postal, United States Postal Service left a package on somebody's porch and you went and took it. That's still theft. And also at the same time, a lot of times now, a lot of these houses, they have their ring lights. So they have like the ring lights up on their porch. So in other words, you may have a neighbor, a person may steal some packages off your porch, but you may have a neighbor, your neighbor might have a ring light that captured it on video. So sometimes law enforcement will ask to see, let me see, let's go to canvass the neighborhood, and see, sometimes you can do it yourself. Talk to the neighbors and say, hey, you know what, my packages were stolen off my porch, let me see if they're in the video on your ring camera. So I want the, law enforcement to see the person, because it keeps happening. They keep stealing my packages. Every time I get my packages, they're being stolen. And then they have disorderly conduct in public areas. And somebody, disorderly conduct, somebody out there, somebody get to drinking, they have a party, they get to drinking, and they don't have to get to drinking, but I'm just saying, disorderly conduct, you can just be acting, you can be acting disorderly. And so that is another petty offense. So let's go to the next one. This is a term I talked about before, precedent. So precedent, that's a court decision in an earlier case with facts and legal issues similar to a dispute before a court. Judges will generally follow precedent, meaning that they use the principles established in earlier cases to decide new cases that have similar facts and raise similar legal issues. So I know in my law class we talked about judges back in England, when judges went down in the towns and they made decisions. They solved cases, they made decisions on those particular cases. Those previous cases became the precedent cases. So that's what they're talking about in that passage right there. So those previous cases became precedent cases. Those important cases that were solved previously, that would be, that could be similar to a current case. That you might, judges might want to look at a current case, but they might look at a previous case that is similar to the present case that they're trying to solve. And then that can be how they make their decision. So they said it's a court decision. Court decision in an earlier case with facts and legal issues similar to a dispute before a court. Judges would generally follow precedent, meaning that they use the principles established in earlier cases to decide new cases. So they use they looking at that previous case. They might want to look at that previous case to solve a new case, because it might be a similar case. So that previous case would be a precedent case. So I call it an important case, my definition. So let me go, let's look at pro se. It's representing oneself. So let me see what they have over here. It says pro se means representing oneself. So I'm going to stop on the definitions in a minute, because I wanted to look up a couple of explorers. Okay, pro se. I don't like to make my video too long. Pro se representation. Pro se representation refers to a situation in which a person decides not to be represented by an attorney. So in a civil or criminal court case, so in other words, pro se, hey, I want to represent myself. The right of an individual to choose pro se representation dates back to pre-constitutional times in the United States. Although individuals have the right to represent themselves, but you can represent yourself and incriminate yourself. So if you represent yourself, you're not really following the Fifth Amendment. I want the right to remain silent. I want to acknowledge the Fifth Amendment for fear of self-incrimination. So, but if I'm up there and I want to represent myself, then I gave up that right, basically. But you know, I'm just saying, say when an individual acts on his own behalf during a legal action rather than through an attorney, he is considered to be a pro se litigant. This Latin term literally means advocating on one's own behalf. In all jurisdictions in the United States, right here where I'm at in the United States, an individual is allowed to represent himself, whether as a plaintiff or defendant in a civil lawsuit or as a defendant in a criminal case. To explore this concept, consider the following pro se definition. In other words, over here in the United States, if you want to represent yourself, you have the right. So they're saying that it's, it's in the Constitution of the United States of America. You can, say in all jurisdictions in the United States, an individual is allowed to represent himself in a criminal case or a civil case. So that's the pro se. So let's move on to pro tem. Pro tem, that means temporary. It says temporary, but let me look that up. Let me see exactly what that means. Pro tem. Pro tem, let me see how much time I have now. Okay, I'm at an hour. I usually try not to make this, try not to make it no longer than 2 hours. But, how y'all doing today? Hope you're having a good day so far. But hit the subscribe button. Try to bring you some law terms. I'm trying to bring some law terms that will benefit, just something to study, something to learn. I think, they're good to learn. Law terms are good to learn. My last video, I talked about broken windows theory, stare decisis, let the decision stand. So that's what that comes under the. What was the term? I just looked. I'm just talking about the precedent. So the precedent also that comes that reminds me of let the decision stand, stare decisis. So when judges made those decisions, those judges solved those cases. Back in the day, common law, that's how common law came about. Judges went into towns, made their decisions, stare decisis, let the decision stand. So what's the word? Oh, pro tem. Pro tem, let me see. So pro tem, it's a pro tempore. Abbreviated pro tem. It's pro tempore. It's a Latin phrase which best translate for the time being in English. For the time being, that means temporary. Okay, it says, what is the meaning of pro tem? An abbreviation used for pro tempore, Latin for temporary or provisional. A person who acts as a temporary substitute serves pro tem. A temporary substitute. The term is often used to describe the acting head of a governing body. So this says, let me see what else they have. Pro tem for the time being, lasting only for the time being. Pro tem legal definition. Let me see what they're saying over here. Okay, pro tem, when it comes to legal, a person who acts as a temporary substitute serves pro tem. I mean, is it a temporary? No, it can't be a temporary lawyer. The term is often used to describe the acting head of a governing body, such as the president pro tem of the Senate. But I was trying to see what does it mean when it comes to law. Okay, here it is right here. Short for the Latin pro tempore, temporarily or for the time being. In law, judge pro tem normally refers to a judge who is sitting temporarily for another judge. Okay, that's what I was trying to figure out. I was thinking about a lawyer being temporary, but it says, in other words, a judge. Let me see. Let me plug this computer up because it's about to go down. I didn't have anything on. Okay, so in other words, the pro tem is a judge. It refers to a judge who is sitting temporarily for another judge. So you go in the courtroom and you got a case that day, or you're a lawyer, or you're a paralegal, you're a lawyer, you're in the courtroom, you got a case, but what if the judge is pro tem? What if the judge is pro tem? And I remember I was watching the channel, the lead attorney's channel, where he was talking about he was talking about the judges sometimes wouldn't even show up. He was talking about the judges. I forgot where was it? I know they were talking about the Shanquella case, and he was talking about. So the lead attorney, he was talking about how the judges sometimes back in the day they wouldn't show up over there, but right here it says temporarily refers to a judge who is sitting temporarily for another judge, or to an attorney who has been appointed to serve as a judge or as a substitute for a regular judge. So in other words, they have judges serving as substitutes for another judge. The other judge, but it said, I don't know why he would be out. It said when an appeals judge or justice is not available, or there is a vacancy, a lower court judge is appointed, justice pro tem, until a new justice is appointed. Small claims cases are often heard by an attorney serving as judge pro tem, short for temporary judge, as Sam Collins is pro tem today. Okay, so Sam Collins is pro tem today. Ms. Walker pro tem today. Okay, so let's go to let's look at the standard of proof. I'll do a couple more. Well, standard of proof right here, the degree of proof required. So, standard of proof, I'm just going to do a couple more, then I think I'm going to move to, then I want to go over a few, I think it's, what is this? I want to go over a few ancient philosophers. Ancient philosophers. I should have went over those explorers. I don't have those over there. I got the ancient philosophers. Okay, I'll go to ancient philosophers. Okay, it's the preponderance of the evidence. That's in the civil. Preponderance of the evidence is the civil law. And criminal law is beyond a reasonable doubt. The preponderance of the evidence lies within the plaintiff. It's a preponderance of the evidence. The standard used in civil cases in the United States, and in criminal cases in some countries, is a standard of proof that requires the bearer show that evidence shows a fact is more likely than not to have occurred. So that's a preponderance of the evidence. I believe that's a lower standard when it comes to civil law. I want to make sure that, okay, no, yeah, right, yes it is. It says the lowest standard of proof is preponderance of the evidence. I was just saying, in a case where the evidence shows that the case most probably occurred as stated by the claimant. This is a standard used in minor civil cases where the outcome of the case is not potentially life-changing. What is the definition of the standard of proof? So that's it. The preponderance of the evidence lies within the plaintiff that comes under civil law, and beyond a reasonable doubt is the standard of proof for a criminal case. It's the standard of proof, the amount of evidence which a plaintiff or prosecuting attorney in a criminal case must present in a trial in order to win is called the standard of proof. So in other words, beyond a reasonable doubt in a criminal case, in other words, you have a jury, that means the jury can't have no doubt. In order for them to convict the defendant, they can't have no doubt. So beyond a reasonable doubt is just criminal. In other words, if they have a case, just say the guy robbed the bank. You know, they're accusing him of robbing the bank, but they have a little doubt. You know, they have doubt. They didn't. Nobody saw him when he came in there. Nobody saw him when he came in there, and or even he went in with a mask on. They didn't know that was him. Basically, they didn't have no evidence to point finger at him. So the jury had some doubt. They couldn't convict him because the standard of proof in criminal cases beyond a reasonable doubt. So then you have the standard of proof in a civil case. The preponderance of the evidence lies within the plaintiff. So what evidence does the plaintiff have that points directly toward the defendant? So the preponderance of the evidence lies within the plaintiff. So if the plaintiff don't have enough evidence, then that case will fall apart as well. So let me see, let's look at statute. So let's look at statutes are your laws. So statutes, definitions are your laws. So I know judges make laws, courts make laws. Let me see what I want to do. Okay, say a written law passed by a legislative body, a law or decree made by a sovereign or by. So this is where it says law, a biblical use, a law or decree made by a sovereign or by God. But it says a written. It said, let me see. It says, what's the difference between statutes and common law? What does a statute mean? Let's go with the statute. The definition of a statute is a written law passed by a legislator or decree by a ruler. When the legislator makes a law that establishes rules for a specific type of taxation. This is an example of a statute. The definition of a statute is a written law passed by a legislator. So laws have to be written by the legislatures. What's the difference between statute and regulation? So I'm not going into all that. So just want to look up a couple more. Sometimes this, computer be running slow. So I got statutes are laws passed by the legislature. I already have it on my paper. Or laws passed by legislature or criminal prosecution. Wait a minute, hold up. No, that's a different word, I think. Laws passed by legislature. Statute of limitations. Oh no, that's something different. Okay, that's the statute of limitations. In other words, the statute of limitations is like a timeline. In other words, you have a statute of limitations may run out for you to file for, to get your money back or file a case or it says it says making, what does the name legislative mean? Making or having the power to make a law or laws, lawmaking, distinguished from executive or as a legislative act, a legislative body. The supreme legislative power of England was lodged in the King and Great Council, or what was afterwards called the Parliament. So, legislature. So legislative body of a country or state. Let me see. It says legislature. A legislature is a governing body that makes laws and can also amend or appeal them. The U.S. Congress is the national legislature. These bodies whose members are often referred to as lawmakers. so make up the legislative branch of government as distinct from the executive and judicial branches. Click to see full answer. So in other words, the laws are made, judges make laws too. So Congress make laws, judges make laws. In other words, when the judges went down in the town, basically years ago, common law, when judges went down in the town and they solved those cases, that became law. When the judges solved those cases and they solved those cases, and those cases became precedent cases. Those cases they marked them down in the books. They became law, and then they used those precedent cases to solve other similar cases. So we have stay decisis, let this decision stand. We have the precedent cases, and we have judge-made laws. Congress make laws. So let's go to statute of limitations. So in other words, statute of limitations, that's like a timeline on the timeline to file deposition for this case. Timeline to get all your money back from, whatever. But it's a timeline. So in other words, you have to make sure, but I like to look it up anyway. I got standard statute of limitations. Okay, statute of limitations. I think it's going to be the last one. Statute of limitations. The statute of limitations, known in civil law systems as a prescriptive period, is a law passed by a legislative body to set the maximum time after an event within which legal proceedings may be initiated. In most jurisdictions, such periods exist for both criminal law and civil law, such as contract law and property law. The statute of limitations, known in civil law systems as a prescriptive period, is a law passed by a legislative body to set the maximum time after an event within which legal proceedings may be initiated. In other words, they have, you don't want the statute of limitations to run out. You don't want the time to run out. You have a certain time. Like I said, in other words, you're a lawyer, you want to file an appeal. You're a lawyer, you want to file an appeal for a case that you have been working on with your client. You have a certain time, you want to file an appeal. You want to file an appeal because you want a new trial. Whatever you want to do, you want to file an appeal before the statute of limitations run out. So that is that. And it's a whole article right here on the statute of limitations. It says when the time which is specified in the statute of limitations runs out, a claim might no longer be filed, or if it is filed, it may be subject to dismissal if the defense against that claim is raised that the claim is time barred as having been filed after the statutory limitations period. When the statute of limitations expires in a criminal case, the courts no longer have jurisdiction. Most common crimes that have statutes of limitations are distinguished from particularly serious crimes because the latter claims may be brought at any time. In civil law systems, such provisions are typically part of their civil and criminal codes. The cause of action dictates the statute of limitations. The cause of action dictates the statute of limitations, which can be reduced or extended in order to ensure a full and fair trial. So, all right, I think those will be enough terms. I'll pick up on these terms tomorrow because I still have like 3 more pages. So I know where I stopped at. So this is some pretty hair that I had. So I'll be working on, this is my mannequin, so I'll be I might do a video, a how-to video. Might do a how-to video, but this is some of the hair, it's real pretty. So then I open it up and it'll spread out, and I sew it all the way, starting from the back, all the way across here, all the way across here, and all the way over here, all the way over there, and so, well, this is pretty hair. And then I have, natural black. So, I have a few more. Look up a couple, let me get this back in here. And these are, this gonna be like a little short wig, short wig, but, so, my mannequin. So let's go look up, let's look up a few, ancient philosophers. So we have, I talked about Plato, Leonardo da Vinci. Some of these on the front I already talked about. Let me see. Let's look up I did an ink pen so I can jot, so I can make my little notes. So I wanted to get an ink pen so I can. Okay, let's start out with Pythagorean. Let's see. Then I want to, then I have some explorers that I want to talk about too. Pythagorean, Pythagorean. Let's see about Pythagorean. It says Pythagorean meaning of or pertaining to the ancient Ionian mathematician, philosopher, and music theorist Pythagoras. Pythagoras of Samos. Pythagoras. So that's Pythagoras of Samos. He was an ancient Ionian Greek philosopher and the eponymous founder of Pythagoreanism. His political and religious teachings were well known in Magna Graecia and influenced the philosophies of Plato, Aristotle, and through them the West in general. So let me see what else they have on. So in other words, they're saying that's they say that he was visited by Plato. So I have I have about 15 or 16 pages, philosophers. Y-T-H-A, Pythagoras. So there we go. Pythagoras. Pythagoras, he is, or simply Pythagoras. It said Pythagoras whole Samios. That seems like a Spanish name, but it said he was an ancient Ionian Greek philosopher and the eponymous founder of Pythagoreanism. His political and religious teachings were well known in Magna Graecia and influenced the philosophies of Plato, Aristotle, and through them the West in general. Knowledge of his life is clouded by legend, but he appears to have been the son of Nesarchus, a gem engraver on the island of Samos. Modern scholars disagree regarding Pythagoras' education and influences, but they do agree that around 530 BC he traveled to Croton in southern Italy, where he founded a school in which initiates were sworn to secrecy and lived a communal ascetic lifestyle. This lifestyle entailed a number of dietary prohibitions, traditionally said to have included vegetarianism, although modern scholars doubt that he ever advocated complete vegetarianism. It said the teaching most securely identified by Pythagoras is metempsychosis, or the transmigration of souls, which holds that every soul is immortal and upon death enters into a new body. He may have also devised the doctrine of Musica Universalis, which holds that the planets move according to mathematical equations and thus resonate to produce an inaudible symphony of music. Scholars debate whether Pythagoras developed the numerological and musical teachings attributed to him, or if those teachings were developed by his later followers, particularly Philolaus of Croton. Following Croton's decisive victory over Sybaris in around 510 BC, Pythagoras' followers came into conflict with supporters of democracy, and Pythagorean meeting houses were burned. They burned his houses. Sometimes, these philosophers, they go around with their views, and sometimes people don't like their views. Like Socrates, he went around, they cited him for corrupting the youth of Athens. They put him on trial. Plato wrote a writing called the Apology based on the trial of Socrates. So Socrates was put on trial, and they told him to drink the fatal hemlock, but then they told him he didn't have to drink it, but he drank it anyway. So Plato's writings were based on the trial of Socrates. So sometimes, like I said, their views are not liked by everyone, and then they have ran into trouble. It said Pythagoras was credited with many mathematical and scientific discoveries. So he had mathematical discoveries. So he had plenty of mathematical discoveries, mathematical and scientific discoveries, including the Pythagorean theorem. And then let me see what else it says about it. It says Pythagoras influenced Plato, whose dialogues, especially his Timaeus, exhibit Pythagorean teachings. Pythagorean ideas or mathematical perfection also impacted ancient Greek art. His teachings underwent a major revival in the 1st century BC among Middle Platonists. So that's Plato. So in other words, Platonists probably the people that supported Plato. That's what it seems like to me. It says Middle Platonists coinciding with the rise of Pythagoreanism, Pythagoras. They have some long words sometimes. Pythagoras continued to be regarded as a great philosopher throughout the Middle Ages. So Pythagoras was a great philosopher throughout, and he was credited for many mathematical and scientific discoveries, including the Pythagorean theorem. I don't know what that was, but he was credited for that. And his ideas, he had plenty of ideas for. He was a perfectionist when it came to math. So he also impacted the ancient Greek art. So I think that's it for him. And also it says Pythagoras, he continued to be regarded as a great philosopher throughout the Middle Ages, and his philosophy had a major impact on scientists such as Nicholas Copernicus, Johannes Kepler, talked about him, Sir Isaac Newton. Pythagorean symbolism was used throughout early modern European esotericism, and his teachings as portrayed in Ovid's Metamorphoses influenced the modern vegetarian movement. Okay, so let me go to another one. So you can look up Pythagoras, Plato, Socrates. So there's a whole lot of them on here that I have never even heard of. So the Pythagoras was from the 4th or the 5th century BC. So we have a peripatetic, the 2nd century AD. So let me see what he was about. So it's a whole lot of them, but it's, and this is, I showed you a picture of Pythagoras. So this is Pythagoras. Let's show him again before I go on. So that is Pythagoras. Hold on. So that's Pythagoras. That's Pythagoras. So he was good at math. He was good at math and science, Pythagoras. So let's go on to the next one is, let me go to peripatetic, P-E-R-I-P-A-T-E. So peripatetic. So I must have spelled it wrong. Let me see. P-E-R-I-P-A-T. P-A is P-A-T-E. T-I-C. Okay, peripatetic. So peripatetic, he must have knew Aristotle. He said the peripatetic school was a philosophical school founded in 335 BC by Aristotle in the Lyceum in ancient Athens. It was an informal institution whose members conducted philosophical and scientific inquiries after the middle of the 3rd century BC. The school fell into a decline. It was not until the Roman era that there was a revival. The term peripatetic is a transliteration of the ancient Greek word peripatetikos, which means walking or given to walking about. The peripatetic school founded by, so in other words, the peripatetic school was founded by Aristotle. It was actually known simply as the peripatos. Aristotle's school came to be so named because of the peripatoi. It said the legend that the name came from Aristotle's alleged habit of walking while lecturing may have started him. Hermippus of Simna. Unlike Plato, Aristotle was not a citizen of Athens and so could not own property. He and his colleagues therefore used the grounds of the Elysium as a gathering place, just as it had been used by earlier philosophers such as Socrates. Aristotle and his colleagues first began to use the Elysium in this way about 335 BC, after which Aristotle left Plato's academy in Athens and then returned to Athens from his travels about a dozen years later. So they did a whole lot of traveling because of the school's association with a gymnasium. The school also came to be referred to simply as a lyceum. Some modern scholars argue that the school did not become formally institutionalized until Theophrastus took it over, at which time there was private property associated with the school. So in other words, that's the school. Peripatetic, that's the school that Aristotle started. So Aristotle started this school, and that's a school where they went to hang out, and they were philosophers, so they gave their views on a whole lot of different things, the way they felt about things, the way they felt about life. And it says according to this article that Socrates and Plato, they also were associated with the school of Peripatetic. So, and then they have a whole lot of different schools. They had a school of Neoplatonic. They had a school of, there's so many different schools on here. They got the Socratic school. So I saw that is associated with Socrates. So many different schools, and then they had the different names. So then we have, let me see, this is Aristotle's school, a painting from the 1880s by, okay, this is the school right here. These are they're just showing you how they were associated, how they got together at the school, and they were all, Aristotle, Socrates, and Plato. So that is them. They said the names of the first 8 scholars of the Peripatetic school are known with varying. So these are the ones who are affiliated with the school. You have Aristotle, you have Theophrastus, Strato, Lampsacus, Lyco, and Troas. They had some different names though. But they're different ones, so I'm not going to read all those names, but you can also read up on the Peripatetic school that was associated with Socrates, Plato, and Pythagoras. So let me see, let me try another name. Let's look for, there's so many of them. Let me look, I just want to pick something at random. Adesia. Let me look up Adesia. So all these, they had influences on the world. They definitely did. So let's look up Aedesia. Adesia, he was a 5th century Greek philosopher. Okay, Adesia. He was a Greek philosopher. So Adesia, He was a philosopher of the Neoplatonic school who lived in Alexandria in the 5th century A.D. So it must be a lady. She was a relation of Cyrenius and the wife of Hermias, and was equally celebrated for her beauty and her virtues. So Plato had his virtues as well. After of her husband, she devoted herself to relieving the wants of the distressed and the education of her children. Ammonius and Heliodorus. She accompanied the latter of Athens, where they went to study philosophy, and was received with great distinction by all the philosophers there, especially by Proclus, to whom she had been betrothed by Cyrenius when she was quite young. She lived to a considerable age, and after she was deleted, or she was no longer here, after she was deleted, oration was pronounced by Damasius, who was then a young man, in hexameter verses. So this is just a short article. This article incorporates text from the publication now in the public domain. So the Platonists, like I said, the Platonists, that's Plato. All the philosophers that were affiliated with Plato were called the Platonists, or Platonists. I would say the Platonists. His name is Plato, so I said Platonists. So you got Plato, Aristotle, Exodus, Philip of Opus, Coriscus, so all the different ones. So you can always read up more on. There's so many of these philosophers. These are a lot of them I've never even heard of. I just want to do probably a couple more, and that'll be it on these philosophers. So you can always do a search and just type in Greek philosophers. Let's look up this one. I think I just did that one. Let's look up, let me look up A. So Aenesagemus. So he's also a Greek philosopher. These names are something else to pronounce. Aenesagemus is a Greek philosopher. It says he's ancient Greek. He was a 1st century BC Greek philosopher from Knossos, who revived the doctrines of Philo, introduced 10 skeptical modes for the suspension of judgment. He broke with the academic skepticism that was predominant in his time. Heraclitus and Timon of Philus, and philosophical skepticism. Although his primary work, the Phryonian Discourses, has been lost, an outline of the work survives from the later Byzantine Empire, and the description of the modes has been preserved by a few ancient sources. There is no definitive evidence about the life of Aenesagemus. What little we know is from a description of his Phryonian Discourses in the Biblion of Photius from the 9th century, as well as a few mentioned in the works of Sextus Empiricus, and to a lesser extent by Diogenes. I think I looked him up too. I talked about him previous, Diogenes. Whether Aenesagemus refounded the Phryonian school or merely revitalized it is unknown, while Diogenes claims an unbroken lineage of teachers. So an unbroken lineage of teachers. So in other words, Aenesagemus, he wrote something called a discourse, the Pythonian discourses to Lucius Aelius. They got these, it's just something to pronounce these words. A friend of Cicero and member of the academy. So like Plato, he had his own academy too. He started an academy. So they were philosophers. They had their little education, their philosophies about different things, about life, love, life. So Plato said love is a serious mental disease. And Socrates said the other than of life is not worth living. It'd probably be better for me to look up the quotes of these people instead of looking it up on here. Quotes may be better. So philosophy, it said the 10 modes of Aeneas Cedimus, that's his name. The 10 modes of Aeneas Cedimus. The reasons for doubt are given in the form of the 10 tropes, also known as 10 modes of Antecedents, or 10 tropes of Antecedents, that represent reasons for. So in other words, different animals manifest different impressions. Similar differences are seen among individual people. So this is the gentleman, I don't think there's a picture of him. This is part of a series, I don't see a picture of him. Since data vary from time to time with physical changes, so these are the 10 modes of antecedents. So in other words, you had the different animals manifest different impressions. Similar differences are seen among individual people. And different ones. I'm not gonna read all of them. And then they have they have a couple of them at the bottom. All perceptions are relative and interact one upon another. Our impressions become less deep by repetition and custom, and all people are brought up with different beliefs. That's true. Under different laws and social conditions. And so I'm not gonna read all that. So let me try another one. Let me see if I can find a simpler one. Maybe one more. I can go through one more. Let me see. Let me try. Let's see. Aetius. So Aetius, he was also a Greek philosopher. So all those ones that I read are Greek philosophers. So it says he was a Greek philosopher as well. He was a 2nd century AD Greek philosopher. None of Aetius' works survives today. So none of his works survives today. He solved a mystery about 2 major compilations of philosophical quotes. There are 2 extant books named De Placita Philosophorum, Opinions of the Philosophers, and Eclogue Physicae. It said the first of these is Pseudo Plutarch, and the second is by Stabius. They are clearly both abridgments of a larger work. In his great, he discovered that in the 5th century he discovered the CE theologian. Theorat had 4 versions of the quotes, which were shortened in the abridgments. This means that Theodoret had managed to procure the original book with Pseudo Plutarch and Stobaeus had shortened. He calls this book, so I can't even read that. That is a long word. It is 1, 2, 3, 4, 5. It is a long word. Look, it says Aetiou. I don't know what kind of language that is. Then it's TEN. The separate word TEN. Then a separate word PRI. Then another word ARESKONTON. That's a separate word. Then another word SUNAGOGEN. So I guess that's a synagoguean. That's the last word. And therefore he ascribed the original Placita to Aetius. So, you know, back in the day, their language was something else. So basically, he was, they saying that they don't have a lot of writings, like Socrates. They don't have, he didn't have any writings. They had Socrates left no writings behind. But this gentleman here was a philosopher, and they said he didn't have any writings, you know. I think they said, well, he had two, well, they did say he had two, there are two books. But they did say none of his works survive. Well, they said none of his works survive today. They said none of his works survive today, but he solved the mystery about two compilations of philosophical quotes. There are two extant books named, so they talk about these books, Opinions of the Philosophers. The first of these, then it said they are clearly both abridgments of a larger work. In his great, so in other words, he discovered in the 5th century CE, he had full version of quotes which were shortened in the abridgments. So basically, they don't seem like they have too much information on him that he left behind. He was merely abridged a work which Daniels called Oldest Tenets, or Latin. It's some, you know what, I'm going to the next one because this is a short article on him. But he was a Greek philosopher. But you can always look him up, because some of these words, I said, ain't no sense me even trying to pronounce them. So I'll put their names, I'll put his name, I'm gonna circle him. So I'll put his name on there. You can always look up him. Aetius, he was a Greek philosopher. Let me try one more. I'll put some of these names on the outside of the video. But it's a whole lot of them. I got like, I don't know, you know, some of these are 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. Ooh, I don't know. 12. Oh, it's more. Then I have this. I have these listed here, and then I have another. You know that I don't know. I got about probably about 20 pages. So, you know, it's going to take some time. So let's try, see, a lot of these philosophers I had not heard of, but just picking out some. Let me go with, let me try Albinus. I've never heard of these, but just was curious. And some of the he was a French abbot. He was a French abbot and bishop. Saint Albinus of Angers. Here you go right here. This must be what, I don't know, but it says Saint Albinus of Angers. I don't know if he painted this. So it says Saint Albinus. So that's what, he's not a painter, so Saint Albinus, well, I guess that, maybe that's where he, maybe that's where they showed up, where he, like Plato had his academy, they had places where they was, go and philosophize, meet up with their friends. It says Albinus. Yeah, Albinus, let me circle him. It says Saint Albinus of Angers. Ooh, excuse me. Also known as Saint Albin. He was born to a noble Gallo-Roman. He was born to a Roman family at Venice, Brittany. St. Albinus was a monk, and from 504 CE, Abbot of Tintalic, which no longer stands, its location has not been satisfactorily identified. His reputation spread during the 25 years in which he served as abbot. In 502, St. Albinus was elected against his wishes Bishop of Angers. So his name is Albinus, but he was selected the Bishop of Angers. So that's why they called him Albinus of Angers. It says he campaigned against incestuous weddings, such as those that occurred between members of the nobility. So he campaigned against incestuous weddings. So I guess family members that were marrying family members, marrying each other. He participated in the Third Council of Orleans after King Childebert granted permission for this council to take place. Albinus sought advice from St. Caesarius of Arles after seeing laxity and other bishops. Tradition states that he helped all in distress using diocesan funds to free hostages from pirates. He did a lot. Another tradition states that he clashed with King Childebert, who had imprisoned a woman called Ethery, but unable to secure her release. Albinus visited her in prison, and a soldier who tried to resist him fell at his feet. And the soldier who tried to resist him fell at his feet. This so impressed the king that he allowed St. Albinus to bail her out. So he went to he went to help this lady that was locked up. He wanted to help her so bad, but he couldn't help her. But somebody else came toward him and fell at his feet. But they were impressed so much that they went on and let him bail her out. Another legend relates that St. Albinus once prayed far into the night for some men imprisoned in the Tower of Angers. Suddenly a great stone collapsed from the wall, allowing their escape. So it says, St. Gregory of Tours remarks on the cult of St. Albinus, which later became diffused in Germany, England, and Poland, making St. Albinus a popular saint during the Middle Ages. So it's just a little bit on him. This is a short article. So in other words, to sum it up for him, he was it says in English, it said he was well, don't say it right here. It says St. Albinus of Angers. He also was known as St. Alban in English, was a French abbot. He was a French abbot and bishop. They tell you he was born to a noble Gallo-Roman family. And they say that he was a monk, but they don't say what a monk is. They say he was a monk as well. He campaigned against incestuous weddings, such as those that occurred between members of the nobility. And he participated in the Third Council of Orleans after King Childebert granted permission for this council to take place. So in other words, he basically seems like to me, he helped families. He campaigned against families that were trying to marry. In other words, you have a brother trying to marry his own, family member, So he campaigned against things like that. And so they made him a abbot and a bishop. And this is just a short little article on him. So these are just some names that I picked out at random. Just some names that I picked out at random. Let me see. I have another list of something. Let me see. Oh, here we go. This is my one right here. Mary. I wanted to look up some explorers as well. So this is Amerigo Vespucci. So Amerigo Vespucci. Let me stand up a little bit. So we have Amerigo Vespucci. He was an Italian merchant, explorer, and navigator from the Republic of Florence, from whose name the term America is derived. So I know we learned in school that Amerigo Vespucci, right, that's how we got our name America. Between 1497 and 1504, Vespucci participated in at least 2 voyages of the Age of Discovery, first on behalf of Spain, and then for Portugal. In 1503 and 1505, 2 booklets were published under his name containing colorful descriptions of these explorations and other alleged voyages. Both publications were extremely popular and widely read across much of Europe. Although historians still dispute the authorship and veracity of these accounts at the time, they were instrumental in raising awareness of the new discoveries and enhancing the reputation of Vespucci as an explorer and navigator. So you know Vespucci, we have Christopher Columbus, we have Balboa. So it said Vespucci claimed to have understood back in 1501 during his Portuguese expedition that Brazil was part of a continent new to Europeans, which he called the New World. The claim inspired cartographer Martin Waldseemüller to recognize Vespucci's accomplishments in 1507 by applying the Latinized form America for the first time to a map showing New World. Other cartographers followed suit, and by 1532, the name America was permanently affixed to the newly discovered continents. So they're trying to say Amerigo Vespucci has some affiliation with America, and that's why we have the name America. But they said Christopher Columbus. Well, they saying that Christopher Columbus was not the only one that stepped upon the American soil. So 1492, Christopher Columbus, 1492. So that was before Vespucci, because see, it said between 1497 and 1504, Vespucci participated in at least 2 voyages. 2 voyages of the Age of Discovery, first on behalf of Spain and then on Portugal. In 1503 and 1505, 2 booklets were published under his name. So in other words, Christopher Columbus, they said a few of them, Columbus, they said he got here in 1492. And then it says, it is unknown whether Vespucci was ever aware of these honors. It says in 1505, he was made a citizen of Castile by royal decree, and in 1508, he was appointed to the newly created position of Piloto Mayor, that means Master Navigator, for Spain's Casa de Contradicción, House of Trade in Seville, a post he held until the end. And it said Vespucci was born March the 9th, 1451 in Florence. I guess that's in Italy. A wealthy Italian city-state and a center of Renaissance art and learning. He was a wealthy Italian city-state. It don't make sense. It said he was a wealthy Italian, it's a city-state and a center of Renaissance art and learning. So in other words, family and education, Amerigo Vespucci was the 3rd son of Nastagio Vespucci, a Florentine notary for the money changers Gill and Lisa Giovanni Mini. The family resided in the district of Santa Lucia, along with other families of the Vespucci clan. So I don't want to read all that about. Let me see what else I have. So that is, like I said, that is Amerigo Vespucci. So they said he also stepped on American soil, Amerigo Vespucci. So then we have, so he also had two older brothers. Oh, here go his brothers right here. Portrait of a young member of the Vespucci family. So he was a younger brother of Amerigo Vespucci. So that's him. But it says Amerigo's two older brothers, Antonio and Girolamo, were sent to the University of Pisa for their education. Antonio followed his father to become a notary, while Girolamo entered the church and joined the Knights Hospitaller in Rhodes. So just give you some, it's a whole lot on him. It's giving you the early career. It says after his return from Paris, Amerigo worked for a time with his father and continued his studies in science. Like 1482, when his father went on, Amerigo went to work for Lorenzo di Pier Francesco di Medici, head of a junior branch of the Medici family. Although Amerigo was 12 years older, they had been schoolmates under the tutelage of Giorgio Antonio Vespucci. Amerigo served first as a household manager and then gradually took on increasing responsibilities. So it's just the early career of Amerigo Vespucci. So it's a whole lot. I'm not going to read all this. It's a whole lot. But here goes some voyages. Depiction of Vespucci's first encounter with Native Americans alleged to have occurred in 1497. So Christopher Columbus, 1492, so this is 1497. It says the evidence for Vespucci's voyages of exploration consists almost entirely of a handful of letters written by him or attributed to him. Historians have differed sharply on the authorship, accuracy, and veracity of these documents. It says, consequently, opinions also vary widely regarding the number of voyages undertaken. So they're really not sure how many voyages Vespucci he took. It said, consequently, opinions also vary widely regarding the number of voyages undertaken. It says, starting in the late 1490s, Vespucci participated in 2 voyages to the New World that are relatively well documented in historical record. 2 others have been alleged, but the evidence is more problematical. Traditionally, Vespucci's voyages are referred to as the first through 4th, even by historians who dismiss one or more of the trips. Alleged voyage of 1497 to 1498. So that's one of his alleged voyages. It says a letter addressed to Florentine official Piero Soderini, dated 1504 and published the following year, purports to be an account of Vespucci of a voyage to the New World, departing from Spain on May 10, 1497, and returning on October 15, 1498. So a lot of times they took their little voyages on their ship, because there wasn't no airplanes back then, so they had to go by boat. So then he had a voyage. So they're saying that he had a voyage. So the first one was, voyages and alleged voyages. So they said they had Amerigo Vespucci, his alleged voyage, 1497 to 1498. Then he had another one for 1499 to 1500. And then another voyage, 1501 to 1502. So it says Vespucci joined an expedition licensed by Spain and led by Alonso de Ojeda as fleet commander and Juan de la Cosa as chief navigator. Their intention was to explore the coast of a new landmass found by Columbus on his third voyage, and in particular investigate a rich source of pearls that Columbus had reported. So they was on their little voyages around the world, stumbling across land, looking for riches, looking for gold, silver. It said Vespucci gave the impression that he had a leadership role, but that is unlikely due to his inexperience. Instead, he may have served as a commercial representative on behalf of the fleet's investors. And then it says the vessels left Spain on May 18, 1499, and stopped first in the Canary Islands before reaching South America, somewhere near present-day Suriname or French Guiana. From there, the fleet split up. So then they had another voyage, 1501 and 1502. But you can read up more on Amerigo Vespucci. So he's claiming to reach America after Columbus. So his dates are different. So then he has another voyage, alleged voyage, and alleged voyage. That means they don't know for sure that he reached these spots. So there probably was no proof. 1503 to 1504. So it says Vespucci may have participated in a second expedition for the Portuguese crown, again exploring the east coast of Brazil. There is evidence that a voyage was led by Coelho at about this time, but no independent confirmation that Vespucci took part. The only source for this last voyage is the Soderini letter, but several modern scholars dispute Vespucci's authorship of that letter, and it is uncertain whether Vespucci undertook this trip. In other words, Vespucci had these letters, and they really can't substantiate that they were even written by him, that he even reached these spots, these different dates that he said, so there's no substantiation of it. So that was Amerigo Vespucci. You could always read up more on him. So it says naming of America. Okay, it says naming of America. A few days ago, I don't have to read that. Let me read down here. It says at the bottom, Vespucci's voyages became widely known in Europe after two accounts attributed to him were published between 1503 and 1505. The Soderini letter, 1505, came to the attention of a group of humanist scholars studying geography in Saint-Dié, a small French town in the Duchy of Lorraine, led by Walter Ludd. The academy included Matthias Ringman and Martin Waldseemüller. In 1506, they obtained a French translation of the Soderini letter, as well as a Portuguese maritime map that detailed the coast of lands recently discovered in the Western Atlantic. They surmised that this was the New World or the Antipodes hypothesized by classical writers. So they wasn't really sure, but they said he's saying he reached these locations, and he had the letters that he wrote, Amerigo Vespucci. The letters that he wrote, they really couldn't substantiate whether that was his writing or not, or because anybody can write a letter for somebody else's name. So they got the Vespucci's letters. It says knowledge of Vespucci's voyages relies almost entirely on a handful of letters written by him, that's what I'm just saying, or attributed to him. So in other words, his voyages relied on a handful of letters written by him, or written by him or attributed to him. So like I said, somebody else could have wrote some letters. 2 of these letters were published during his lifetime and received widespread attention throughout Europe. Several scholars now believe that Vespucci did not write the 2 published letters in the form in which they circulated during his lifetime. See what I'm saying? They say I don't think he wrote them. They suggest that they were fabrications based in part on genuine Vespucci letters. It said 1503 was a letter written to Vespucci's former schoolmate and one-time patron. Originally published in Latin, the letter described his voyage to Brazil in 1501 and 1502, serving under the Portuguese flag. So I'm not going to read all this, but this is something you can read more up on Vespucci, Amerigo Vespucci. Read more. So in other words, they're saying they can't really substantiate the letters that were written to him. They were written by somebody else. I guess that's what they're saying. Or they can't really substantiate the ones that he wrote himself. Vespucci has been called the most enigmatic and controversial figure in early American history. The debate has become known among historians as the Vespucci question. How many voyages did he make? Can you substantiate any of those voyages that he made? How many did he make? What was his role on the voyages and what did he learn? The evidence relies almost entirely on a handful of letters attributed to him. Many historians have analyzed these documents and have arrived at contradictory conclusions. So you can read more on Amerigo Vespucci. So it's a whole lot. It's a nice article right here. I printed it all out. This is the last page right here. It said Vespucci's historical importance may rest more with his letters than his discoveries. Burkhard City, the naming of America after him as an example. Yeah, see what I'm saying? That's what I said they named. We learned about him in school, how they learned America. They named America after him. And it says, Burkhard Cities, the naming of America after him, as an example of the immense role of the Italian literature of the time in determining historical memory. Within a few years of the publications of his 2 letters, the European public became aware of the newly discovered continents of the Americas, according to Vespucci. So you can always read up on it said the statue of Vespucci outside the Uffizi in Florence, Italy. So this is a statue of Vespucci. That's a statue of Vespucci, but you can always read up on more of him. So that's a statue of Vespucci outside the Uffizi in Florence, Italy. So that's a statue in Florence, Italy. I don't know if it's still there or not. Might not be there now. Oh, this time, but it may be still there. Florence, Italy. And Amerigo Vespucci Monument. Just the Amerigo Vespucci Monument. El Chico, Colombia. That's the Amerigo Vespucci Monument right there at the bottom. Amerigo Vespucci Monument at the bottom. So let me stop this video because I don't want it to be too long. Yeah, so here go Amerigo Vespucci. Show it to you again. But I want to end this video right now because it's over 2 hours. So you can always look him up. And then I have some other explorers that I want to bring forward. But I want to say thanks for joining me today. Thanks for joining me. Glad you could be here. Glad to see you. So I want to say I'll see you on my next video. So my dog collection. So I want to say I'll see you on the next video. Thanks for joining me. So, my dog collection. But thanks for joining me. Hope to see you on the next video. Subscribe below, comment below. Like I said, any ideas that you have for me, any terms you want me to look up, any terms you want me to look up, any law terms, any other terms, any terms that you think that you want the world to know, you want the community to know, you think we should know, you know. I don't mind doing a little research because I'm always open to learn new terms. I'm always open to learn, just learn, you know. Learning is a never-ending process. So learning never stops. So learning never stops. So if you have any terms, you have any law terms, you have any other terms that you want to, you know, let me know about, you know. So, you know, drop a comment in the comment section. Subscribe to my channel. And so I'll be showing you my doll collection as I collect them. And also, yeah, I do have some Barbie dolls too. So I have 4 of these dolls right here. 4 of these dolls here. Then I do have some Barbie dolls. So I'll be showing you my little collections, you know, my videos. As I do my videos, I'll show you my collections. And I'm also going to be working on my, you know, I might show you how I make my wigs on one of my videos. So, I'll see you on the next video. So, have a blessed one. Bye.